Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome back to Talk Law Radio. I'm Todd Marquardt on 9:30 a.m. The Answer, Facebook Live, YouTube, and podcasts everywhere. Call us at 210-308-8867 if you have strong feelings about the recent Supreme Court case called Students for Fair Admissions versus President and Fellows of Harvard College. It was just recently decided. I also want to mention our new sponsor, Financial Planning HQ. Are you looking for true financial planning to help you make the best decisions about your money? Instead of trying to sell you overly complicated financial products, Financial Planning HQ focuses on creating comprehensive strategies that give you and your family the highest probability of achieving your goals. For a complimentary consultation with Joseph Warren from Financial Planning HQ, call 210-748-6699, 210-748-6699. The Supreme Court case that was just decided, Students for Fair Admissions versus President and Fellows of Harvard College, is just the most recent Supreme Court case about affirmative action. In order to understand what's been happening with affirmative action, I want to take you through a trip in history. In Regents of University of California versus Bakke was a case where Alan Bakke was rejected twice from the medical school at the University of California, Davis. He was white, and he argued the school's affirmative action policy to reserve 16 out of 100 spots for qualified minority students violated the Equal Protection Clause as well as the Civil Rights Act of 1964. The Supreme Court ruled that the racial quota system used by the university did violate the Civil Rights Act. So in that case, we learned that universities could not have a quota system. And let me just explain another principle of constitutional law here. We have an amendment, the 14th Amendment. It specifically says that laws have to be applied equally to everybody. Well, if you apply policies such as admissions policies unequally because you want to diversify your student population, well, that violates the Equal Protection Clause. But there was an exception. You could racially diversify your student population. That was an exception to the law, but you had to follow certain parameters in creating those exceptions. And so the courts would always they would strictly scrutinize the policy or the law in question. That's called strict scrutiny. Race could be a narrowly tailored factor in admissions policies. Racial quotas, however, went too far. So that's one of the standards, is that the policy has to be narrowly tailored to a compelling state interest. And back in 25 years ago, the court said that the state did have a compelling interest to diversify student populations at universities. So that's why discrimination was allowed. Okay, that case was dated in 1978. And that was the rule until 2003. In 2003, Barbara Grutter, a white woman who was denied admission to the University of Michigan Law School, said that the school had used race as a predominant factor for admitting students. The court ruled that the admissions decision was based on multiple factors, and the school could fairly use race as one of those factors. So the case reaffirmed the court's position that diversity on campus was a compelling state interest. That same year, there was another case about Gratz versus Bollinger. Jennifer Gratz and Patrick Homaker, both white, were denied admission to the University of Michigan. They argued that the point system used by the admissions office was unconstitutional. Students who were part of an underrepresented minority group automatically received 20 points in a system that required 100 points for admittance, which meant that nearly every applicant of an underrepresented minority group was admitted. The Supreme Court ruled that the point system was unconstitutional. And so we had all these universities trying different things to create a diversified student body. The quota system was not allowed. The point system was not allowed. But you could use race as a factor. So those were the rules until 2016. There was a case about Abigail Fisher, a white woman who was rejected from the University of Texas. There was a two-part admission system which took race into consideration. The university first admitted roughly the top 10% of every in-state graduating high school class, a policy known as the 10% plan, and then would review several factors, including race, to fill in the remaining spots. The court ruled that the university's policy met the standard of strict scrutiny, and the school could be given reasonable leeway in its review process. So that was part of the decisions up to this point. And that brings us to year 2023 in the case of Students for Fair Admissions versus President and Fellows of Harvard College. The question was, could race be used as a factor in admissions? And another question was, Title VI of the Civil Rights Act bans race-based admissions that, if done by a public university, would violate the Equal Protection Clause. Is Harvard violating Title VI, penalizing Asian American applicants, engaging in racial balancing, overemphasizing race, and rejecting workable race-neutral alternatives? So remember, if you're taking notes about constitutional law, there are several things you need to keep into mind. The 14th Amendment, Civil Rights Act, Brown versus Board of Education, and then these Supreme Court decisions. And what the court is saying today is that eliminating racial discrimination means eliminating all of it. Distinctions between citizens solely based on their ancestry are by nature odious to a free people whose institutions are founded upon doctrines of equality. Racial and ethnic distinctions of any sort are inherently suspect. But there was the exception that you could have a policy or a law that discriminated, but it would be strictly scrutinized, and there had to be a compelling state interest, and the use of race had to be narrowly tailored to achieving its goal. So let's talk about what the admissions policies were. At Harvard, each application for admission was initially screened by a first reader who assigned a score in each of 6 categories: academic, extracurricular, athletics, school support, personal, and overall. For the overall category, a composite of the 5 other ratings, a first reader can and does consider the applicant's race. Harvard's admissions subcommittees then reviewed all the applications from a particular geographic area. The regional subcommittees make recommendations to the full admissions committee, and they took an applicant's race into account. Then the full admissions committee began deliberations. It discussed the relative breakdown of applicants by race. The goal of Harvard's policy was to ensure there was no dramatic drop-off in minority applications from the prior class. An applicant receiving a majority of the full committee's votes was tentatively accepted for admission. At the end of this process, the racial composition of the tentative applicant pool was disclosed to the committee. The last stage of the process was to winnow the list and to arrive at a final class. So the cuts at this stage were placed at the top of the LOP list, which contained 4 pieces of information: legacy status, recruited athletic status, financial aid ability, and race. In the Harvard admissions process, race is the determinative tip for a significant percentage of all admitted African American and Hispanic students. So we'll see whether that was narrowly tailored to a compelling government interest. The other part of this case was University of North Carolina's policy. In their process, there was similar. There were categories, there was race. But here's where it differed. Someone would receive a plus depending on the applicant's race. Okay, so that's really the only thing that was different there. And so the court held that they remembered from the Grutter decision, which was 2003, 20 years ago, the Grutter decision, the court wrote that there would be a final limit on race-based admissions programs. At some point, the court held they must end. It said, recognizing that enshrining a permanent justification for racial preferences would offend the Constitution's unambiguous guarantee of equal protection, the court expressed its expectation that in 25 years, the use of racial preferences will no longer be necessary to further the interest approved today. So it's been 20 years since then, and the court ultimately held that 20 years was enough time for racial inequalities to be evened out. Remember, we talked about strict scrutiny. Any exceptions to the Equal Protection Clause's guarantee must survive a 2-step examination known as strict scrutiny. Whether the racial classification is used to further compelling government interest, and whether the government's use of race is narrowly tailored to achieve that interest. Student body diversity was decided to be a compelling state interest in that case, Grutter, back in 2003, 20 years ago. Those limits intended to guard against 2 dangers that all race-based government action portends. The first was the risk that the use of race will devolve into illegitimate stereotyping. Admission to programs could not operate on the belief that minority students always or even consistently express some characteristic minority viewpoint on any issue. The second risk was that race would be used not as a plus, but as a negative to discriminate against those racial groups that were not the beneficiaries of the race-based preference. We've been talking about the affirmative action case in the Supreme Court. If you have feelings about that, strong feelings one way or another, give us a call at 210-308-8867. We got to take a break, but we'll be right back.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the Ten Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.